If a buyer, maybe if they find problems with the property after the contract date or after settlement, are there any kind of remedies that they would have there?
After settlement, in most cases, no, there's not a lot of remedies, depending on what it is. So I have had some issues recently with smoke alarms where the buyer has found out after settlement date that the smoke alarms were in fact not compliant, even though the seller gave notice in the contract that they were. Because again, in Queensland contracts, if the seller gives notice that the smoke alarms are compliant, that's enough. The risk then goes to the buyer to prove that they're not. So in most cases, I guess buyers don't really know what they're looking for. If they see that the smoke alarms are compliant in the contract, they might rely on that. And then they have to arrange an electrical inspection themselves to prove that they're not. Now, if they don't do that and we settle and we find out after settlement they're not compliant, there's not a lot the buyer can do under the contract. So unfortunately, it has to be raised before we settle.
So Vanessa, thanks for joining us on the show.
It's okay. Thank you for having me.
Last time we spoke about some of your conveyancing ordeals, and today I thought it'd be a good idea to kind of dive a little bit deeper into it. Tell us a little bit about the process of selling a property, and can you maybe share us an example where things have gone wrong?
Okay, I can do that. So to start with the process of selling a property in Queensland is the seller obviously puts their house on the market. So they can sell it through an agent or sell it privately. It's up to them. So as we spoke about last time, due to new laws, sellers have to provide a disclosure statement. So they have to get that underway first, so either before they hit the market or afterwards. So they find a buyer, great, negotiations between the buyer and seller, they agree on their terms for selling the property, and a contract is drawn up. So the way we recommend doing it is that a solicitor reads over the contract once it's been drafted. So in Queensland, the real estate agent does this in most cases. So we have a look over it. We explain the terms and conditions to the sellers and the buyers and recommend any changes. We explain how they work. And once we finally have an agreement on the terms and conditions, the contract is finally signed up, first with the buyers and then usually the sellers sign last. And that's when the contract is dated. So once the contract's dated, that's when the due dates start rolling in. So we've got, in most cases, finance, building and pest, and the settlement date all calculated from that date. So that's the basic terms of how it's done.
I guess that's the basic drift, but it sounds quite simple when you put it in that way, but I imagine some things go wrong, and I just want to get an understanding as to what things can go wrong at that period of time. So I imagine there's, with the contract of sale, it's a fairly standard contract across the board, but then you have special conditions that can alter that. So what are the things that can go wrong at that stage that stick out to you?
Okay, well, I do have a lot of examples to give you. I guess I'll keep it brief because I have been doing this for a little while now. So some things that can go wrong with, for example, contract drafting. Special conditions drafted by a solicitor can save the deal. In one case, for example, I have actually had a house burned down. So properly burned down, fire and all. The house wasn't completely destroyed, but the house was unlivable. So most buyers will notice when I review their contracts, I always recommend doing a seller's risk special condition. So the reason for this is because in REIQ contracts, the risk of the property actually passes to the buyer at 5 p.m. on the first business day after the contract date. So this means anything that happens to the property after the contract date, the buyer's insurance has to pay for it.
That sounds a bit absurd to me. So I know about this condition. So let's put it into practical terms. You've got a seller that's living in the house and they're selling the property, and they sign off on a contract on Monday saying, we're selling this property to Hayder. Hayder's coming to buy the property. And then on Tuesday, I haven't moved into the property. I'm in the process now to try and settle the property. But on Tuesday, if the house burns down and, Vanessa, the seller, is living in it, then Vanessa can say, well, it's not my problem anymore. It's Hayder's problem because he signed the contract the day before. Is that right?
If it burns down on Wednesday, Sure, because
On
that would
Wednesday. Yeah, sorry, the following day
if it
after
yeah,
that.
the next business day, yeah. So if it were to burn down on
It'd be
Wednesday,
terrible
yeah,
if
it
it,
is
if, it-
your
if it burned down at like 5:15 or something on the Wednesday on the
running
next day.
matters. So it matters.
Yeah.
Yes, if that were to happen, in that case, your insurance would need to pay for the house. So
Okay.
that's unfortunately, that is the way it is. I think in most cases, this isn't being explained to buyers enough when they're signing contracts. I find a lot of the time the contract gets to me and I mention this to buyers and this is the first time they've heard about it. So it would be better if they were told a bit earlier on in the piece that, by the way, this is how it works with insurance.
It is a bit of an odd condition, and I know in other states they don't really have such a condition. Do you know why that has originated in Queensland and why it's a standard condition?
The origins of it? No, I don't actually know the origins of why they've
Yeah.
decided to do that in Queensland. I do know that it's been there for a very long time. So, as long as I've been doing it, it's been a standard clause. So, it's a bit ridiculous that the only winners here really is the insurance company, because when we act for the sellers, we always recommend they keep their insurance in place until the settlement date, just in case. And then buyers, of course, without that seller's risk special condition, they have to get insurance as well. So really, two people are insuring the one property. So
I
seems
guess
a bit
there's the answer
overkill.
there. The insurance companies maybe lobbied the REIQ in order to get that condition in.
Maybe. But yeah, we've got two policies on the one house. So yeah, there's one winner here and it's not the buyers or sellers.
So then what happened in that example where the property went up in flames?
Well, in this example, there was a seller's risk special condition. So luckily, the buyer was able to walk away. We had to get rid of the contract because there was no house to sell, and the seller's insurance had to pay for it. So that was
Yeah. And if that special condition wasn't in, then you'd have a buyer that is liable for the damages there.
correct. So that could have been worst case scenario, but luckily that buyer had the correct condition in their contract, so they were able to walk away from that one without their insurance having to pay up.
Yeah, and in that example, would the buyer then be obligated to continue with the contract, or would they still be able to withdraw from the contract because the house is just in not the same condition as it was before?
Yes, so the buyer would be able to get away from the contract in those cases. So obviously the property has to remain the same condition it was at the contract date, I guess, depending on the state of the property. So if it were substantially destroyed, there's no property to sell and the contract's frustrated.
Yeah.
But yeah, depending on how bad it is, but you can still live in it, the buyer would say, sorry, this is going to cost me too much money. Under the terms of the contract, they can terminate and walk away. It depends, which is the
Yeah.
lawyer's favorite phrase.
And so let's talk about if a buyer, maybe if they find problems with the property after the contract date or after settlement, are there any kind of remedies that they would have there?
After settlement, in most cases, no. There's not a lot of remedies, depending on what it is. So I have had some issues recently with smoke alarms where the buyer has found out after settlement date that the smoke alarms were in fact not compliant, even though the seller gave notice in the contract that they were. Because again, in Queensland contracts, if the seller gives notice that the smoke alarms are compliant, that's enough. The risk then goes to the buyer to prove that they're not. So in most cases, I guess buyers don't really know what they're looking for. If they see that the smoke alarms are compliant in the contract, they might rely on that. And then they have to arrange an electrical inspection themselves to prove that they're not. Now, if they don't do that and we settle and we find out after settlement they're not compliant, there's not a lot the buyer can do under the contract. So unfortunately,
Yeah,
it
like
has
what
to
are
be
they going to do?
raised
Chase them
before
up?
settle. Yeah.
Yeah. The pathways are limited. What about after signing the contract?
After we sign a contract, I've had so much with this recently. Okay, so if you find something wrong with the property after you sign the contract, if you have a building and pest condition and you find these problems under the building and pest inspection, great. You can raise that with the seller and negotiate, repairs, price reduction, or terminate the contract altogether. If you do not do a building and pest inspection and you get to settlement, you realize, hang on, there's all these things wrong with the contract. Oh, sorry, the property. We then get stuck into this argument of were the problems there before the contract date, whether they're after the contract date. And it's then on the buyer to prove that these issues came up after they signed the contract. So again,
Yeah.
it's
How are you going to do that? Obviously it depends on the damages, but it doesn't seem like a good position to be in. How are you going to show whether there's cracks or foundational issues that occurred before the contract or after the contract date?
Exactly. It depends on whether you took photos when you inspected the property, were these things, I guess, apparent in the advertising photos, and was the buyer given a copy of a building and pest report before signing the contract? So depending on what the issue is, a good lawyer then has to dig through these reports and photos and find out, was the buyer aware of this before they signed the contract, or is this actually something that's happened since they've signed?
And with the building and pest, like if you wanted to withdraw under that, have you seen like any real strange issues that have come about because of that, or any reasons for wanting to withdraw from the building and pest that seem quite minor? Like how serious does it need to be there?
Again, I've seen all sorts of reasons for people terminating under building and pest. I've seen some pretty bad ones where the build was done, not to standard, and generally major defects, reasons for people to terminate under building and pest. I have seen people terminate for minor defects. So the way the building and pest condition works is that a buyer has to act reasonable when trying to terminate under the building and pest inspection. So what's reasonable? That's up
Well,
to the buyer
give
to
us an
argue.
example of something that was minor.
Okay, so I do have a lot of buyers bringing up random minor issues like the tail rail is loose. That is a minor issue, but for some reason everyone brings it up, and I wouldn't recommend trying to terminate a contract under those sorts of issues. That is minor. A light globe doesn't work. Is it because the light globe is just blown and you just need to replace it, or is there a deeper electrical issue behind that light globe? So on and on it goes. So that's kind of the things that you see under building and pest. But I would always recommend to my buyers, like when you're reading a building and pest report, you need to look out for major defects, major issues that are going to cost them money after settlement. So things like there could be moisture in the wall. That means there might be a leak back there that's causing all sorts of damage. That's the sort of things that they should be looking out for.
Focus on those big issues. Don't worry about like the towel racks and the light bulb.
Don't worry about the light glow. Don't worry about the tail rail.
Yeah.
Sorts of things. If there's a screw loose, you can probably get a screwdriver and fix it.
Yeah. We're talking about $1 million transaction here.
Correct. But we get caught up on these little details every day. So
yeah.
Watch.
Okay. And the next question I had was about delays in settlement. How do you see that happen quite often? And what's a valid reason for delaying settlement and what's not a valid reason?
There are a lot of delays lately with the banks is the most common one. So obviously people, they get their finance in place, whether it's cash or finance approval. There are delays with people completing their settlements due to banks not being ready on time, whether that's on the bank side or whether, the buyer hasn't or the seller even haven't completed the documents they need to in time. The great thing is there is a clause 6.2 in contracts now. It's a standard clause. So should we get to settlement and there's a delay with the bank, something has happened at the last minute where they've asked for a document and the buyer needs to run around and get that document to the bank, either party can operate the 6.2 clause, and it's an extra 5 business days from the original settlement date. So they can use that, get extra time. That was introduced because we were getting to settlement and, things went wrong with the bank. They needed extra time to settle and the other party said no. And they terminated the contract and took their deposit. So that was happening a lot. So they like to put this new clause in contracts to give people that little bit of, that grace period to organise that.
And what about after that? If you can't finalise the docs by that time, after you've exercised that?
After you've used up your full 6.2, that's when we get into the problem area where you have to request the extension and the other party has to agree.
And if they don't agree?
That's when we get into the danger zone. So if they don't agree, you default under the terms of contract.
You can lose your deposit.
Seller can take your deposit and sue you, potentially. Or buyers, if the seller's not ready, they can get their deposit back and, again, potentially sue the seller. So not a good spot.
It's a big warning for buyers. If you're not ready,
Correct.
If you're not ready to purchase by the settlement date, if your finance is not in order, which is really probably the main reason the finance is not in order.
Yeah.
If that's the case, then you could be up for a huge loss of funds and potential court case as a result of it. So before you sign on the dotted line, make sure you got the right advice.
Correct.
Okay. And have you seen any kind of transactions where it starts to get into the world of fraudulent? We've got a lot of scams that are going around, and people are worried. They should be worried because it's becoming increasingly common. Have you seen anything like that where someone's put forward like fake transaction details, or has purported to be somebody that they weren't when they were trying to buy or sell property? Is that a real risk that is out there?
It is. It is a very real risk. It hasn't happened to me personally, but at a previous job of mine, it happened to a colleague where she was corresponding with someone over email, someone that we thought was our client, corresponding back and forwards regarding the settlement figures and, getting ready for settlement. The client then called the office saying, I haven't heard anything about my settlement. What's going on? This person hasn't contacted me. And she said, what do you mean? I spoke to you this morning on email. It wasn't our client at all. Someone had got a hold of our client's email. They were obviously gearing up to intercept the email and send fake bank account details for settlement. But luckily in that case, there was no disaster. So we were able to say to the client, oh, someone's hacked your email, change your password right now. But it is obviously a huge issue in the industry where if bank account details are given over email, they have to be verified over the phone. This is a common cybersecurity issue. And it has happened to firms where a client has given their bank account details over email. It hasn't been verified over the phone. The client's then called after settlement saying, where's my money? Fake bank account details were given, so that money's now.
Can you imagine? You just sold your biggest asset that you've worked so hard for to maintain, and comes to settlement, and the funds that you're expecting to hit your account just don't.
It does. And it does happen to firms as well, where emails can be intercepted by us, where we send our trust account details. That can be intercepted, and someone could say, sorry, we've changed our trust account. Please pay it into this account. And, never act on that. Always call the firm and confirm that's their account details. Because on the flip side, that has also happened where clients have put money into this account. The solicitor calls the client before settlement saying, where's your money? I said, I put it in your account. No, they did not.
Yeah.
So another disaster. Hasn't happened to me personally, but
Another thing I've seen is having somebody use like an email address that is very similar to somebody else's email address. Like, for example, H Shkara and changing it to H-Shkara or something like that. And all of a sudden you're corresponding with someone that isn't purporting who they're supposed to be. It's really troublesome. And I feel like a lot of people are just not in front of these types of issues, and it's not top of mind. And especially if people are busy and doing lots of transactions, then it can quickly escape them.
yeah, exactly. Like if you're not really paying much mind to it, you just see, an email from Hayder and say, oh, okay, he wants this and he sent me this link that I need to click on. And I better get onto that right now without, paying much mind to it because you're busy. So that is something
Yeah.
that happens a lot.
Well, have you got any other examples of cases that have gone wrong?
I do. I have some for you. All right. So another tip that I give buyers when looking into properties is, do your research on insurance before buying a property. Because we already touched on the whole seller's risk clause in contracts. Depending on where your property is located, make sure that you can get insurance on the property and what the insurance actually covers. I have had obviously a disaster case where the buyer couldn't get insurance on the property due to not meeting the, the minimum levels, I think it was, for flooding. And due to that, it actually burnt down. So disaster. So
God.
yeah, so research definitely matters. So, sometimes if a property is flood affected, it might not be a, major flooding, might be minor and just in the background, but obviously make sure that you can get insurance and what it covers.
Yeah. And I guess it's like if you can't get insurance, then maybe you should, that's also a bit of an alarm bell. Like if the insurance company is not going to cover that particular property,
Yes,
there's probably a
definitely.
reason as to why. Like they're not going to turn back money unless they've done their research and
Yeah.
they've assessed the property to be a risk.
Yeah, definitely. That's something you should be looking at before signing the contract. If it's something that comes up after you've signed the contract and you've realised, oh no, I can't actually get insurance on this property, buyers do have a cooling off period. Another case where a deal has fallen through and things have gone bad. There was a matter where we had a license agreement in the contract for the buyer to take early possession of the property before settlement. So this is a very common agreement that I'm seeing in contracts at the moment, where there was negotiations before signing the contract and they agreed for, the buyer to take early access or just move into the property entirely before settlement. So I'd have a situation in the past where there was this agreement and the buyer moved in before settlement. For whatever reason, the buyer didn't have the funds and they just could not settle. So after many extensions, the seller had had enough and terminated the contract and told the buyer, leave the property, contract's over, you have to go. The buyer refused. So this is where things get very hairy. Due to the circumstances of granting the buyer possession of the property, the matter had to go to the Supreme Court to get
Wow.
an order to remove the buyer. So this is different to, tenancies and QCAT issuing an order for possession, whereas early possession in Queensland, if you let someone into your property and they refuse to go, it can get very, very expensive to move someone out. So in most cases, solicitors say, don't agree to this, because if things go south, it's very hard to get them out and very expensive. So
Okay,
as
so
you
even
probably
if
know,
there's a written contract or agreement or license agreement prior to them moving in, signed by both parties, it's still difficult to get them out.
well, in this case, it wasn't, it was just a special condition in the contract. So this is why, legal advice matters and why drafting matters. So this was just an agreement for them to take early possession. They moved in. There was no tenant-landlord relationship. So the owner granted this person possession. So the only way to get possession back was through the Supreme Court. So as you know, that's not cheap.
No.
Something that buyers need to keep in mind when agreeing to these things. So I find a lot of the time buyers and sellers are agreeing to this without getting any legal advice. And then in most cases, we say, don't agree to it. So, and that's why.
Yeah. Yeah. So in that instance, would it work if it was a separate tenancy agreement drawn up for that? And that way they'd be kind of considered as a tenant and maybe a bit more actionable under QCAT. But still, it sounds
Yes,
a bit messy anyway. You don't want to go down that path for,
exactly. It's
3 or 4
messy either
weeks
way.
of early rent or something.
Yeah, exactly. There's risks involved in both cases. So in most cases, we say, look, if they need to move in somewhere because obviously they've got that gap in between moving out of a rental and moving into this property, find alternate accommodation or find, some other agreement where it doesn't involve them moving into a house because it can go south.
Okay. Amazing. Oh, no, that's really good information because I think a lot of people, when they are negotiating, it might be kind of this casual chat. They think, yep, we're doing a favor for someone. Sounds pretty easy. Yeah, you're just going to move into the house a little bit earlier. You're going to live here anyway.
Yeah,
Sounds
yeah,
all good and dandy. No, but when it comes to the crunch, there's all these what ifs that haven't really been considered.
yeah, exactly. It's all good until it's not.
Yeah.
That's what I find a lot. So again, with the special conditions as well, poorly drafted special conditions could cause so many issues at settlement. Like I've had recent settlements where the special condition wasn't clear enough on what had to happen and it's resulted in so much back and forth and disputes between me and the other lawyer. So for example, if we write into the contract, the seller has to fix the fence. Like how much fence? What parts of the fence? Like the whole fence?
Which fence?
Which fence? Yeah, the back fence, like the entire thing. So, that wasn't clear enough. And we got to settlement and parts of the fence that they thought they were fixing were done. But the buyer said, no, that fence over there's not fixed. And yeah, and then arguments unfold.
Yeah, yeah. I can see how that happens. Vanessa, thank you so much for your insights. Always good to have a chat and to hear what's going on in the world of property transactions. Of course, if you do need an excellent conveyancer, you can hit up Vanessa at CJC Law. She does all purchases and sales across Queensland, so is able to handle your transactions. Thank you so much, and we'll hope to have you again soon.
Yes, thank you for having me.